All right. Hello, everyone. This is Curt Barone.
And Brad Pinsky, and I am back in action.
There we go. Back from Italy, and we are here for another edition of Fire Law Roundup for October 2nd of 2023. October. I can't believe it. So
I know. Well, happy almost Halloween to everybody, right?
Yeah.
All right. Well, today we have some interesting cases. They're not the run-of-the-mill cases today. I was really kind of excited to see we're getting a little bit off the harassment discrimination bandwagon.
Oh, we can never get too far from that.
Never get too far. We got one, and it'll always come back. But today, let's start. This is really, really interesting. And I think, frankly, it could be a whole course, but we're going to start in Florida, where we have a line of duty death that was filed. Let me give the basic facts. So there's a Florida firefighter who died when a trailer that was filled with sand, and this was a trailer owned by the fire department or the city, and it flipped, pinned the firefighter, causing significant injuries. There were numerous surgeries. Ultimately, days later, the firefighter tragically died. This was not on a call. This was moving sand from one place to another. And the trailer's used for, I guess, hazmat incidents. But now let me be clear to everybody. This is a lawsuit. It's just filed, not a court decision. These are allegations I'm about to repeat. So the allegations, which I find extremely interesting from a legal point of view, are that the trailer was defectively and dangerously constructed, that it was dangerously designed, it was dangerously maintained, and more important, that the city failed to provide proper training on how to use it when this individual who died and another person were ordered, according to the lawsuit, to utilize it. So
Brad, I want to point out, I don't know if you saw the video, but the trailer itself, look, I don't know if, did you watch the video?
I did not.
There was actually a couple of videos that I watched, but bottom line, excuse me, the trailer had two wheels. And you think about a trailer like this, it's going to carry 4,500 pounds.
Gonna be a 4-wheel or 6-wheel, yeah.
Well, I know mine is I have a 9,000 pound trailer that I use to move my tractors, but it's got 4 wheels, and it makes it a little bit more stable, a lot more stable. And then there's jacks and different things to stabilize it when you're moving stuff on it. But it did look to me like it was a 2-wheel trailer that, has if it's not connected to something or it's not braced, has the potential to tip one way or the other. So the reason I say that is when I first read the article, I'm saying a trailer tipped over. I'm thinking it went over on its side, but I think this went front to back.
Yeah. And, and if people haven't used trailers, for example, I learned that hard lesson where I have a motorcycle trailer and I've always brought my motorcycles in with it connected. Well, one day I didn't have it connected. I bring the motorcycles in. What happens to the trailer? The whole thing tips up and you're right.
Was it a two-wheel trailer?
Two-wheel trailer.
Yeah.
It's not normally meant for loading, but if it is, it's got to be connected to something or held down, which is a bad way to do it, with like a cement block or something on the front, which is what landscapers do, but it's not a good idea. So here's why this case is so interesting. And I don't know Florida's laws, right? But let me predict the case. In most states or many states, obviously, as we all know, you can't sue your employer for injuries on the job. And because you're an employee. So when you get injured, you get workers' comp. That's what you get. Now, maybe also this, there's in New York, we call it a 207A, but it's the difference between the full amount if you were killed in the line of duty or something, or your full amount of your salary and benefits minus the workers' comp section. So usually it's like, comp might pay 2/3 of your salary, but this is the third that's filled in by special laws for firefighters, police officers, et cetera. I assume Florida has something like that. On the other hand, it doesn't include pain and suffering. And it doesn't include what's called loss of consortium, which is where, okay, you're married and now your wife has additional expenses because you're not here, right? So just getting comp never helps anybody because it's just comp plus that additional missing third to give you your full wages, maybe, right? And for your anticipated life of service, et cetera. But then there's more. And this individual lived for, a number of days, probably in great pain, consciously suffering. And if this was a normal motor vehicle accident where somebody was hurt like this, who wasn't an employee, they would get a lot of money. So the question here is going to be whether Florida allows a lawsuit against its employer for not something that was part of the anticipated dangers of firefighting, right? But was instead for just daily routine maintenance, etc.
Well, they alleged gross negligence, and I think that was why I didn't see a count there for straight negligence.
Yeah, and they're probably trying to get around. There must be something in Florida that if it's gross negligence, right, on the basis. And look, this really could be if they gave no training to use a trailer, which people who use trailers know are dangerous and can be dangerous on properly stabilizing, loading, securing, etc. This is a good suit. It's not that this isn't a good suit. The issue is going to be what are Florida's laws that prevent this type of suit, whether it's a comp law. And look, I'm hoping, I assume not, but in some states, the employers fight you saying, we're not going to give you the difference between comp and your full salary because this wasn't a heightened danger of firefighting. That those usually don't fly, but that's the defense the employer would offer. I'm assuming the employer wouldn't put that forth here, but I didn't see anything about that here where they say they denied it, but that would be in a different court too. It wouldn't be part of this. But this is really interesting. And, again, it's a little bit different than most firefighter cases because it's not line of duty injury as we would think about it, right? It's performing their duties, but not while firefighting. So who knows? I suspect you'll see a settlement.
Yeah, I think so too. One of the things I was speaking to a group last week, and when we were talking about the fact, like one of the challenges sometimes is a department, when they may have done something wrong, do they investigate it? Should they investigate it? Like something, hear me out on this.
Yeah, I know where you're going. Okay. I know where you're going.
Because the reality is in a classroom, when you give a scenario in a classroom to a bunch of chiefs or a bunch of officers and say, should we investigate this? Oh, yeah, we should investigate this. And I said, in real life, there's a lot of pressure on you not to. And in this case, at least the video that I saw, it sounded like that clip, and I believe the video is in there. Yeah, one of the interviews of the chief, or they're actually a video of the chief saying that they're going to stop the investigation, that the lawyers had recommended that they stop the investigation. And I'm like, it's exactly what I was speaking to this other group about, that we're under such pressure sometimes. And again, in a classroom, it's not real. You're dealing with a tabletop, just a theoretical problem. In real life, there's a lot of pressure on you not to investigate, or at least to do some sort of a superficial kind of investigation that's going to make you look good. Certainly isn't going to make you look bad.
Right.
And that can conflict sometimes with what the victims in a scenario like this are looking for. The parents are looking for some sort of an acknowledgement by the department that we realize we got a problem and we're going to fix it.
Right. And look, if you have a true health and safety officer, I've mentioned this in past times, but if you have a true health and safety officer, the health and safety officer is going to make sure we investigate every near miss, every close call, et cetera. If there is a history of this, on the one hand, you could argue, well, your investigations are going to hurt you because you knew you had a dangerous, right? On the other hand, we investigate and we put proper procedures into place. You're not going to see that in this lawsuit, so we don't know. But our advice, I don't want anyone to take, at least what I would say is always investigate. If it's disclosable, it's disclosable. Yeah, okay.
But that's the opposite of what they teach us in law school.
Yeah. Right. And then there's a question of, are the investigations public record? Are they disclosable? And who cares? Investigate. If you did something wrong, you did something wrong. This isn't about covering it up. This is about doing the right thing. And, sometimes things go wrong, but investigate and correct.
Right. And, my son's a doctor. He's actually a surgeon. And he was taught, even before he became a surgeon, when he was just in medical school and then as a resident, that when you make a mistake, you own it.
Right.
You own it.
Yeah.
Because, and you tell the patient, or if the patient didn't survive, you tell the family that this is what happened. And, we thought this, but we did this, or we nicked his liver, or we nicked the spleen, or whatever it might have been. You acknowledge it. And they've got research that shows that when you do that, number one, you're less likely to be sued.
Right.
And number two, when you are sued, your the payout that you're going to have to pay out is typically less. So this is not what they're teaching lawyers, though. The lawyers they teach you to set your hair on fire and run around. Like, don't admit to anything. So I think that we've got a conflict here, but I think the department in this situation needs to investigate it, figure it out, and make the adjustments accordingly, and that will actually reduce your liability. Believe it or not, it's counterintuitive, despite what your lawyers may tell you.
Yeah, and definitely never take advice from your insurance lawyers on how to do this, right? The insurance company lawyers, because they're even
They have
worse.
a sort of a short-term outlook on things.
Yeah, no, but you're 100% right. And look, in the professions, physician profession, certainly the lawyer profession, we are mandated to self-report. And when if we commit professional malpractice, which would be our negligence, we have to self-report it. In fact, in New York State, under many of the model rules, you have to report someone else. And if you fail to report someone else, they get to report you for not reporting them. So we are so heavily, but that's how it should be.
Oh my God.
In the fire world and all world, right? And that's why I like dash cams. That's why I like videos where there's no question what happened. Right.
Instant replay. It's the real world equivalent of instant replay. And we know how important that is to pro sports. So
yeah, true. Now let's go from video to photo. So let's go to Kobe Bryant. This is a very simple case. This was a right holding. This is the decision. Here we have a captain who claims he was ordered to take a picture of Kobe Bryant family in that horrific helicopter crash. As many know, what was the number, 26 million, or they lost?
30. I think the total ended up, Vanessa Bryant ended up with 31 million, but that was a jury verdict. There was 2.5 million to some of the other survivors and so on. I think the total ended up being somewhere just under 40 million. With attorney's fees and everything else.
So here, this is one of the captains who was ultimately found not to have done any wrong, right? Was vindicated, but then says, I want my attorney's fees. And when I'm first reading this, I'm like, well, I should get his attorney's fees, except he was offered an attorney and turned it down. And also, and this is important, failed to give notice to his employer by within a certain month of time, 6 months of time, had to give notice that I'm being sued, etc. So here's what I'm saying to everybody watching this, right? Because to have some value to this, it has interest value, certainly. But if you are personally sued, especially fire chiefs, because we always see the fire chief personally sued, do not assume that your employer is going to provide a defense for your union or anyone else. If there's a law like there is in New York and many other states, including California, if there's a law that says you have to provide notice to your employer that you've been sued, which many or most, states have, you darn well better have proof. And I get a receipt. I tell everyone, you hand the copy of the summons and complaint that I'm getting sued or a threatening letter or whatever, but don't give up the original or don't give up something. Have proof that you turned it in. This individual lost one of two reasons, because he didn't give I
think it was more complicated than that. I think what he was saying, here's what he was saying. He was saying that he was told to take the pictures. And then a deputy chief told him, get rid of the pictures. And that's wrong. And that right there, and now whether or not the deputy chief did or didn't, I don't want to get into that. I have no idea whether the deputy chief did, but the allegation is the allegation is that he was told to take the pictures. He took the pictures, and then a deputy chief told him to get rid of them and tell everybody he didn't actually take them. Okay. So what he's alleging is that put him in conflict with the city's attorneys. And therefore, that is what or allowed him or required the city to pay for an independent attorney. So that's problem number one. What he didn't do was he didn't file under the state's Tort Claims Act.
Right.
So it wasn't that he didn't turn over because they were named, the county was named in the suit. So the county was aware of it. But the challenge here is that he did not file, he was alleged a tort and he didn't file within the time period
6
for
months,
the tort
yeah.
claim.
Yep.
And he tried to allege there was a continuing violation, and the court said, no, you should have, if you're going to claim a tort, you should have filed by that.
Right. And the conflict issue, I think, is more interesting because
Yeah.
it is a conflict. There's zero question when you're pinning two employees under the same employer against each other, there is inherently a conflict, period. So
Right.
in that right, but that didn't buy him any victory here.
No.
But again, people got to be very careful. And if there's a conflict, your lawyer should be demanding that they cover, right? That's normally what happens, that they cover, and those happen up front. Normally insurance companies, if this was an insured claim, I didn't see what, or self-insured, I don't know. But
I can't imagine. I can't imagine
either. So the insurance company, even if they just covered the defense, will normally provide, when there's a claim of a conflict, will normally provide another letter or lawyer to prevent all of this. So I don't know how it happened. I was a little shocked that there would have been, or if the lawyer didn't ask, or I don't know those facts, but
right. Yeah, no, I spent a little bit more time on this one just because I've been following this. There's 6 lawsuits against the Los Angeles County Fire Department. Now there's other suits against the county sheriffs and all that, but there's 6 total lawsuits involving the Los Angeles County Fire Department over this one incident, which involved taking pictures. And good God, I mean, at this point in time, we should at least have some sort of a policy regulating this and managing this. And then it's just a question of, supervising and managing the process now. But the potential here for up to $40 million in claims out of this one incident is remarkable.
And I got to tell you, and you do the same thing when we draft policies for our clients. I'm always saying there's no reason to take pictures on a scene other than on an official camera, on a dash cam. I said, but stop allowing Joe Firefighter to take a picture on the scene. It's a recipe for a disaster. Just bring dynamite to the fire. It'll go just as well. That it's going to be the lowest common denominator. Firefighter is going to leak it or post it or do something with it. Have faith that they're going to do something stupid. Why? Because we're stupid. I don't know. It seems like a good idea until it's not. So
those who've taken my digital imagery class will know I go in a different direction. And that's fine. That's what makes the world go round.
Right.
That's fine. But
my
point is, we got to manage it. You got to manage it. You can't just let people take pictures whenever they feel like. The picture taking is got to be managed, and then what you can do with the pictures, has got to be managed, and that's a lot of work.
And how you store them, how you preserve them, when you can delete them.
It's a lot of work. That's a lot of work. I had a dentist appointment this morning, and I'm leaving the dentist office. We caught a run right down the street from my house, so I ended up getting there. But I just ended up taking 2 pictures at the incident. It was a washing machine fire, but take the picture of the serial number and the name of the information that I need for the NFIRS report. Okay,
but there's a difference. You have rank.
I do, and we also have the benefit of my policy, which dictates what I'm supposed to do with those, where I'm supposed to archive them, how I'm supposed to archive them, and all that. Right. So, and they won't surface on Facebook. So,
I was okay. So let's stay in LA. Now, here's why, going back to the first case in Florida with the trailer, here's why I think that Florida will ultimately settle, because sometimes it's just the right thing to do, whether or not you have legal liability. Sometimes it's cheaper for whatever reason. LA County. Now, you and I covered this. I don't remember the date, but you and I covered
not that
this
long ago. Yeah,
it wasn't. And it was good because it settled very quickly. But basically what happened here is there was known feuding between 2 firefighters who I think were at different stations.
No, same station. They're both engineers at the same station. Yeah.
Oh, okay. And then one firefighter leaves, returns with a gun, and fatally shoots the captain, or fatally, shoots a guy named Carlton. And there's the wrongful death suit, and the allegation was the employer knew that this was a dangerous individual, that they had violent incidents between them, a workplace violence incident. By the way, there's a federal workplace violence requirement to have a policy and address this. This should have been addressed under that. And since the county was aware of the individual's, I'll quote, longstanding, threatening, bullying, combative, angry, and unsuitable behavior. Now, the only word I get there is the words I get there are threatening and combative. Maybe angry, but unsuitable is, if somebody just said you're unsuitable, your behavior is unsuitable, I wouldn't think you're going to go home and get a gun and shoot me, right? But nonetheless, if the question would have been, right, if it went to trial, did you know, would a reasonable employer have anticipated that the assailant was going to go home and get a gun? Was it to that level? And they thought it was, worth settling. So this is where I think the trailer will go. Which
well, this is a tough case because trying to predict somebody's behavior from their past behavior, particularly somebody who's sort of spiraling downward, it is difficult for professional psychologists and psychiatrists to do. Right. And so it's difficult for chiefs. And I think for that reason, you've got to bring in experts. The union can be sometimes an antagonist because, you try to send somebody for an evaluation. And if you don't have it in the collective bargaining agreement, you've never done it. Now they're going to pose some obstacles for it. And I'm not saying I have no idea what happened in this case, but you want to think through this. And I think the best way to do it is the leadership of the union, leadership of the department need to kind of work out a process for workplace violence before you attach a name to it. So it's not reacting to, Brad or Curt or some known quantity. But get in there, set up a policy, involve the EAP folks with it as well, and then let the experts guide the department. If somebody needs some time off, if somebody needs to go away, whatever it may be, let's get them the help. But what happens, I think, sometimes is we were kind of caught off guard by an allegation that somebody is out of control and we don't really know how to deal with it, and we don't deal with it. And, this is the unfortunate type of result that can happen. And again, I'm not saying that's what happened here. Maybe the department did everything they should have done. And it's very difficult to predict this type of outcome.
And your smaller departments sitting watching us are saying, wait a minute, we don't have a psychiatrist or a psychologist. We don't have an EAP program.
You need to get a phone number. You don't have to hire them. You don't have to have, but you need to have somebody who is able to assist you. And, you and I talk about it all the time. We're not doctors. Okay. So that when somebody brings us a doctor's note, we're not, it's not for us to dispute what the doctor has said. Maybe we get another doctor to dispute what the doctor said. But we're not experts. And I think, we've got to understand our limitations. Big fire department, small fire department, we need to have some sort of expert in this area that's going to be able to help us make better decisions here.
Right. And look, what I do almost inevitably is I tell my clients, let's say the smaller or mid-sized fire departments, I tell them, remove the person from duty. If you think something's off, and this could be for depression, this could be for anything, remove them from duty for their own benefit. They don't need to be subject to anything more that could inflame PTSD or anything. And and protect the public, protect the firefighters, but then tell them they have to go get psychological evaluation or anger management or something real. And if they can't afford it now, in many states like New York, I'm sure California, in many states, the insurance companies give you a set number of mental health visits. So if you have health insurance, which with Obamacare and others, most places do have some sort of health insurance, you are guaranteed a certain number of mental health visits, and departments should use that, right? Yes, maybe you cannot afford your own psychiatrist or psychologist or mental health team at your department, but most places, most people who have insurance have that mental health benefit and never use it. And I encourage everyone, go get, counseling for no reason at all. Just keep yourself tuned up. But here they have a chance to get it. And a true psychiatrist or psychologist will diagnose something, I presume, and then intervene, hopefully. But if you do that, you have taken the liability off. I hate to talk about this in lawyer terms, right? But if you do that and you remove somebody for duty, you send them for an evaluation, now they're evaluated and they're returned, you're off the hook as far as I'm concerned. What more can you do? You send them to a doctor, right? And that's what they've done. We're not doctors. They've evaluated. You're off the hook. But if you think you're going to die, I'm just repeating what you said. If our firefighters and fire chiefs think they're going to diagnose somebody on their own, and that's going to say, oh, no, he's fine. You're playing with fire, right? Because we're not experts on that.
For sure. And just on the psychologist end, I mean, there's diagnosing somebody, and let's just throw something out there, paranoid personality disorder. You can diagnose somebody with a paranoid personality disorder, but you can't predict that it's going to escalate to this.
Right.
That becomes almost expecting somebody to have a level of clairvoyance that just doesn't, it's not reasonable. So, but again, I think you're right that we've got to take certain steps to justify and do our due diligence on our end as the leaders, and then let the psychologist, psychiatrists do their due diligence, and hopefully most of the time we'll end up with an outcome that benefits everybody, as opposed to what happened here.
And my last word on that is, I've never once seen the I turned a blind eye defense work. What did a chief so-and-so, what did you do in response to these complaints? Oh, we turned a blind eye. We thought it would go away. I've never seen that work. So,
and I doubt LA County turned a blind eye, because I've got some friends up, in LA County high up, and certainly I'm sure they handle it as best they could. But I think for other departments that don't have the resources, like you suggested, you need to find resources in the community. And if you have an IAFF local and you have an EAP program, the folks who are experts in, drug and alcohol, they're not going to be experts in violence, but they may have friends that can be brought into the circle, and then they become a resource, just like your regular EAP folks.
Right. Just chiefs, we have and I mean this, we have a bad history of thinking we have to be able to solve everything, because that's our right. That is our role on a scene.
When the doors go up, the bell goes off, the doors go up. That's what we were expected to do, and then you just progress in the front office and you take the same mentality.
Yeah. And I think that's the problem with it.
Sometimes you got to call a special signal.
Yeah. Okay. Let's see. We've hit California twice. We've hit Florida. Let's come right back up to down in my area. Let's go to New York. This is a lawsuit. Again, everything I'm going to state is an allegation, not a fact. I don't know how many times we can say that, but I know.
Oh, just keep saying it. Just keep saying it, because somebody will miss it.
Yeah, no question. So we're going to go to Peekskill, New York. This is in eastern New York, in the Hudson Valley region. For people who know, we have a firefighter. Now, this is a paid fire department civil service exam, right? So when you take a civil service test to be brought on the job, you take a civil service test to be eligible for promotion. And I'm giving this as background, not that it's right in this case, but the civil service has what's called the rule of threes in New York. You have to take the three highest candidates, or the candidates with the three highest scores. So there's a lot of discretion that's removed by law in who you hire. However, once you are all within the same scores, now there is a subjective basis for hiring and for, in this case, promoting, and it's the subjectivity that's always going to get us into trouble. So here's what we have. We have a Peekskill firefighter, paid firefighter. He says he's been passed over 3 times for a promotion from firefighter to lieutenant. And then he also claims retaliation, which I'll talk about. But he is I believe, is he a Middle Eastern descent? He doesn't say Muslim. He just says Middle Eastern descent, and noticeably so through skin color. He claims he has been passed over, and they use the term objective, which is smart on the lawyer. He was passed over in favor of, quote, objectively less qualified non-Middle Eastern candidates, for all of whom white Irish American individuals. I can't imagine they're all Irish, but you know, in the fire service, look, we're all Irish.
Irish American.
Except the Italians who, you know, I don't want to get the hateful email. Nonetheless, they said, you know, he says, I've been passed over. And so here, as you and I have said, maybe 1 million, 2 million times, it's hard to count. But I am hoping, and we'll get more into the allegations, but I am hoping that they have objective criteria why they chose these individuals. And that's what's going to come forward. So everybody who has a hiring or promotional process, if you're asking subjective questions to everybody and you don't have an objective measure, where I like the point system, we're going to give you X points for years of service, X point, right? Whatever your matrix is, even though the giving of points might be somewhat subjective, right? But years and positions held, they're objective. So here, I hope, for the sake at least of the fire department, that they have an objective way to prove, okay, we took these firefighters in lieu of the Middle Eastern appearing firefighter, you know, and here's why we did so. One time, your fire department's probably not going to lose. 2 times, yeah. 3 times, you better explain yourself, Lucy, right? You got some explaining to do. So in addition, this person also claims that as he made some complaints, he was retaliated against in terms of assignments. We got less favorable, less desirable tasks. I should have gotten more desirable ones. I'm senior. I have seniority. He claims that he was denied certain awards and recognitions, and that's kind of a spiral, right? Well, these people got awards, so they got the lieutenant position. You didn't get an award, so you don't get the lieutenant position. And then you say, but I should have gotten the award. You were just, you know, discriminated. And then finally, you have the, which I do want to talk about more. He claims, we see this a lot, I was injured on the job. We see this all the time. I was injured on the job and you denied me benefits. And that's where I want to pause for a second and question. In a department, when somebody is injured, why is the fire chief or anybody else in the middle of the department? I'm not saying that's what's happened here. I'm asking the question. Why is the fire chief or anyone in the department making a determination of whether it was an on-the-job injury or not, right? The department should provide the facts and investigatory results. This is what we were doing. This is how we were injured. This is the video or the witnesses. This is what we saw, right? But the department shouldn't be directly and isn't usually the one making the determination of whether it's a comp-based or, you know, on-the-job injury. Maybe in a big department, it's HR. In the small departments, in some states like New York, it would be the workers' comp board would make a determination.
Well, I can answer that, but I don't want to answer it in the context of this case because I have no idea.
Yeah, let's do a general.
I'll answer it in the context of my experience, because they think the person either got hurt in their part-time job and dragged themselves to work and now is claiming a work-related injury, okay?
Which happens.
Or they're a phony, okay? That there really is no injury. They're mad about not getting promoted, or they're mad about this, or they're mad about that.
Or they think they're going to get fired anyway.
It's not a real injury.
Right.
But as you properly point out, it's not, you know, you can't be going on your chief experience when it comes to medically related types of things. You know, we want to do an investigation and get witness statements and all that from people who either saw it or didn't see it, or we want to have a private investigator go figure out, did he get hurt, you know, doing his carpentry job or some other job or off the department. Go ahead, get the expert, go do that. But don't sit in the office and say, yeah, I think Verone's lying. I don't think he really got hurt, and therefore we're going to turn him down.
Right.
So now, again, I don't know if that's what happened here, okay? But I will say the fact that he got passed over 3 times on the rule of 3, and they're busting his agates here on the work-related injury part suggests that possibly the chief's perspective on this guy is that you know, he's not a favored son, and you know, he's worn out his welcome maybe or whatever, but certainly doesn't seem like he's being treated as somebody who's on the A team. Whether it's justified or not, that may be an entirely different thing.
Right, right. But I guess to say it this way, he's going to make it past a motion to dismiss, and you're going to be put in front of a jury more likely, or someone else to say, are you right or not?
Yeah.
So, okay. But again, I go back to, and I'll end here just reciting that when you hire, don't hire. When you promote, I hope you're not just making up promotional processes. I hope you have an objective point-based system. I like point-based systems.
Well,
Yes,
most of them,
giving-
I will tell you, most of them on the rule of three, they don't. Like the chief likes this guy, I'm going to go
Right.
with this guy, or the chief likes that guy, we're going to go with that guy. And they don't really have that kind of within the civil service system. Like you have the civil service system, but
Right.
once you get into like that best of three, a real formal process for doing it. The safest thing to do is just the guy who's number one gets it. You know, that's the safest bet. But you're right. I mean, you want to have some sort of an objective process to.
And the reason we don't is because, look, most of the fire service is white males. I'm not going to say white Irish males, right? I'm Jewish, but right, white Irish males, white Italian males, white males. That's most of the service. So when we're doing a promotion, we're never concerned with, I'm going to discriminate against one white male with another white male. But you throw a female or a minority in the mix, now it changes, and it forces you to change the process. We have seen cases, and I think this is why we have seen cases where, and I'll end with this, but this is a really important point. We have seen cases where the person who's discriminated against claim, well, they just changed the process when I came in it. They used to do a different process, right? And now they have this new process. But the reason they've changed it is because someone realized, wait a minute, they're not all white males coming up for promotion now. We need a more fair process. However, you don't want to be in the position of somebody saying you changed the process just because I was coming through the promotional process. So do it now, create a new system now. And, these are not easy. This is not for, high school or college grad people. Creating promotional exams, promotional systems, which are not, biased in any way, that takes a master's or PhD level person. Don't just create it. You spend some money now, and you won't spend money later defending your bad process. Okay. Ohio, let's end with this. Thank God at least it's not a firefighter stealing this time, but Jesus, we have the mechanic in a fire department who took some fuel cards. It wasn't even smart, I guess. It took some fuel cards for vehicles that had been retired. I think old retired ambulances, took the fuel cards out of them, didn't cancel them. Now, shame on the department, by the way, for not canceling them, but maybe that was his duty. Who knows? And he gives them to family members who are then using these fuel cards to fill up their vehicles or gas cans and then selling it. I mean, they've all been indicted. 6 of them have been indicted for stealing $75,000 worth of fuel, right? But this goes to a couple of things, and this comes up all the time in my life, unfortunately. Whenever I hear the word fuel card, it causes me, pain. But fuel cards are abused constantly. I don't like them. There's not a great way around them. I would say a lot of fuel card theft is probably not discovered, and almost inevitably how it gets caught is the gas station owner says, I saw somebody not in a fire vehicle using this card, and they turn them in. In my experience, that's how I've seen it. But fuel cards, somebody needs to be in charge of overseeing fuel use, monitoring. Well, you had $200 this month, all of a sudden you have $600 now. You got to monitor it. You got to look at fuel logs. This is a job for someone to do. I am telling everybody, fuel card theft is common. I've never seen this, right?
Well, I got
one.
an idea. Let's assign it to the fleet manager.
Yeah.
Yeah.
Until he's a crook, right? And I get it. It makes sense to assign it. Every person can't be supervised. Somebody's right. At some point, you can't have a supervisor for a supervisor. So I get how this happens. That's why they're going to jail. But please, everyone, look at your fuel cards use. And that is the end of today's roundup.
All right. Yeah. And there's a few other cases this week that were interesting. I'm going to cover them, couple of them at the beginning of this week. So stay tuned, and we've got more good law cases coming. There's no shortage.
And hey, thank you for everybody, because I'm told, I believe we've passed our number of viewers and viewable hours, that we moved up into YouTube
Yeah.
graces. I don't know
Yeah.
what it is.
No,
Just,
we're up over 4,000 total viewing hours in the last 365 days. So I'm working with YouTube now. I got to fill out this form, I feel like I'm at the Department of Motor Vehicles getting a new, but filling out this form, filling out that form. And so, hopefully we'll start seeing some, excuse me, some ads showing up pretty soon. So.
thank you
All
to
right.
everybody for your continued support.
All right. And that's going to do it for another edition of Fire